Good morning. The meeting of the Louisiana Tax Commission is hereby called to order. The meeting is being held at the offices of the Louisiana Tax Commission at 1051 North 3rd Street, Suite 225, Baton Rouge, Louisiana. The date is Wednesday, April 22nd, 2026. The time is 9 a.m. Please call the roll.
Chairman Roussel,
Here?
Commissioner Leone,
Here.
Romick,
Here.
Commissioner Guidry,
Here.
Commissioner Frazier.
Here.
5 present and a quorum.
Thank you. There being no old business, we'll move on to the approval of minutes.
Mr. Chair, I move to approve the minutes from the meeting of April 8th.
We have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Chandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 965 change orders. Staff has reviewed those change orders and requests to approve 919, place 44 in pending status, and deny 2. Staff requests approval of the change orders.
Mr. Chairman, I move that we approve the 919 change orders and place 44 of those in pending status and deny 2 for reasons given by staff.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Chandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 26 prior pending change orders. Staff has reviewed those change orders and requests to approve all 26. Staff requests approval of the prior pending change orders.
Mr. Chairman, I move to approve the 26 prior pending change orders as reviewed and requested by staff.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Chandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 2 tax sale cancellations, 1 in Washington Parish due to being erroneously sold, and 1 in Caddo Parish due to being erroneously sold. Staff requests approval of 2 tax sale cancellations.
Mr. Chairman, I make a motion to approve the 2 tax sale cancellations.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. We'll move on to the ratio step.
Good morning, Mr. Chairman, members of the commission. Jeff Crosby on behalf of the appraisal section, along with Mike Allen, the assistant director. We are here today to present the results of the 2025 whole property residential sales ratio study. The study composed of comparing residential sales from the time period of 2022 and 2023, the sale price to the assessed value. The study was done in all 64 parishes. We used the median and the COD to determine the accuracy and the uniformity of assessment, and our results found that Tangipahoa Parish was the only parish outside of the tax commission guidelines. The accuracy, which is reflected in the median ratio, was 8.5, which needs to be between 9 and 11 to be acceptable. But I will say the COD, the measure of uniformity, was at a 986, which is very good. So they were uniform. They were just a little low. The study was done in all 64 parishes. All assessors and taxing bodies were notified of the results. I'll be glad to answer any questions you may have.
Okay. We'll hear from the assessor from Tangipahoa if you'd like to make some comments, but is there any questions on the actual report before we hear those comments? Okay. Assessor?
Kevin Rayford, Tangipahoa Parish Assessor. Mr. Chairman and Commissioners, thank you for your time. Just a couple of things that I'd like to kind of have on the record. Obviously, I just took office in January of 25. As stated, the values that he just reviewed were not under my direction or in when I was in office. I do find it kind of interesting, and no negative reflect on anyone, but from talking to other assessors within our region or within our state, that it seems to be a normal thing that a new assessor seems to deal with this type of issue, where they fail the tax ratio study whenever they take office. Not really sure why that reason seems to be. Just seems to be a little unfortunate for me taking over in January that I get hit with a failure of a ratio study when it seems to me like maybe if there would have been some trends that maybe would have been discussed before it didn't seem to me like the cliff just ended. It seems like it would have been a gradual, and it may have been something that, and I'm just trying to look going forward, that maybe people would appreciate if they knew something was coming so they could address it. There's plenty of things that we've started doing since I took office. All of you guys know, obviously I was the CFO before, and whenever I took office, I hired Patrick Matthew, who worked here at the commission. So there was obviously things that I knew I wanted to do to be better. Unfortunately, I feel like I didn't get the opportunity or the time to do that. And unfortunately, in my area, in my constituents, now I'm dealing with the pressure of tax bills going up $800 to $1,000. And I'm the one having to take that burden, and I didn't do it. And I just feel like that's, if I'm just being honest, I just feel like that's tough for me to have to take that on when it wasn't my doing that did it. I obviously seen and had the foresight to bring in staff to try to correct the problem, just didn't get the opportunity to do it. And I get there's things in places, but I just felt like there might have been an opportunity to where it could have been brought to my attention and said, hey, we see this is here. We're going to give you X amount of time to try to fix the problem before we have to do what we do. And I just don't feel like that was what I had the opportunity of doing. I understand we all have things that we have to do, and we're fixing it. Tangipahoa Parish Assessor's Office is headed in the right direction, and I want to make sure you guys know that we're doing everything on our side to make sure we don't sit here again.
Thank you, Kevin. And I can assure you on behalf of the commission, we will continue to work with the parishes. And you're right, if we can improve when someone's close to passing or close to it and doesn't, give me a heads up so that, hey, this is on the horizon so that you don't get caught on a cliff.
I would appreciate that.
Yeah, but we sympathize with you being the new guy, because when we first got here, we were the new guys too. They got stuck with some stuff. So, but I appreciate your comments and I thank you for being here.
Thank you. I appreciate it.
We need to make a motion.
Mr. Chairman, in light of the results of the 2025 residential whole property sales ratio study as presented by the Appraisal Division, establishing that the fair market values of residential properties in Tangipahoa Parish were outside the tolerances allowed by Article 7, Section 18 of the Constitution of Louisiana and Louisiana Revised Statutes Title 47, Section 1837, I move that an order of reassessment be issued, directed to the assessor for Tangipahoa Parish, ordering that all residential properties in Tangipahoa Parish be reappraised and/or reassessed as needed to conform to the standards prescribed by law.
And we have a motion. Is there any discussion on the motion? If not, is there any objection to the motion? Hearing none, motion is adopted. We'll move on to the next item on the agenda.
Chairman, the next item on the agenda is consideration of a written objection filed by the assessor in the matter of Northgate Mini Storage LLC versus Assessor Bobby Edmondson and the Bossier Parish Board of Review, docket number 25-22015-001. It's the assessor's objection, so I would suggest Mr. Edmonton can go first, and then the individual here representing the taxpayer, after he introduces himself, can respond, certainly any questions you have, and then chair can entertain a motion on the assessor's objection.
Good morning, Commissioners. Brian Eddington. I am pinch hitting for Reed Jones, who filed the motion, but unfortunately wasn't able to be here today. Mr. Jones has objected to two specific emails. Now, they're spread over 4 pages because they appear twice. They're in emails dated March 11th, 2025 and May 20th, 2025. And they involve discussions over a potential compromise of the 2024 assessment for the prior year. Louisiana Rules of Evidence, Article 408, specifically provides that settlement discussions are not admissible. Northgate Mini Storage's opposition is kind of interesting. First, they say these aren't settlement discussions. These are just part of the assessment process. If you look at the emails, they're clearly settlement discussions. The assessor specifically references that we are discussing 2024, where the taxpayer had paid under protest, but did not file an appeal to the tax commission. He specifically states, I'm still trying to work with you. There are specific deadlines. If you don't accept this offer by a certain date, and he kept extending it, that the offer expires. They're clearly on their face settlement discussions again for tax year 2024 that had already concluded. They were not part of the assessment process. They certainly weren't part of the assessment process for 2025, which they were just receiving the LAT forms at that point in time. Their second argument is that Assessor Evanston waived any objection. Apparently, these emails were submitted to the Bossier Parish Board of Review. I don't know if it was in 24 or 25. Long story short, we don't have any record. They may have submitted them to the Board of Review. They didn't submit them to Assessor Evanston at that time, and he can't waive an objection to a document that he does not know was admitted. And regardless, what may or may not have happened at the Board of Review is really irrelevant. You're not reviewing the Board of Review's ruling. You're reviewing the correctness of the assessor's assessment. Again, Article 408 of the Code of Evidence precludes admissibility of settlement discussions. These two emails clearly are settlement discussions and should be stricken from the record.
Good morning, Mr. Chairman and Commissioners. My name is Anthony Gambino. I represent Northgate Mini Storage in Bossier Parish. I'm here. All right. Sorry, guys. Oh. Riveting stuff happening on YouTube today. Yes. All right. Wow. I don't know why you're torturing your wives with that. Anyway, I'm appearing as counsel for Northgate Mini Storage, the taxpayer in this case. My client had to hire counsel to be here today because the Bossier Parish tax assessor is attempting to hide communications with its taxpayer as a part of the discussions that it's supposed to have with its taxpayer as an initial matter whenever there's an issue with the assessment. And so before I get into those procedural tactics, I do want to lay out some of the facts. And what the facts clearly show, commissioners, is that in 2023, the property was assessed for $222,000 in fair market value. The very next year, the Bossier Parish tax assessor assessed it at $913,000. Northgate did not even receive notice of this change as required by law, and evidence next month at the commission hearing on this, the correctness of this, we will show that the assessor admitted that we did not receive notice. If you accept the assessor's math, we're talking about more than 300% increase year over year. But the property is functionally obsolete. We're talking about a mini storage that has no air condition, 100% of the doors have to be replaced, the roof and insulation have to be replaced. It's in an industrial area with low occupancy, but the assessor would have you believe that something occurred between 2023 and 2024 that would increase the assessment by over 300%. So how did Northgate respond? It did exactly what it was supposed to do. It reached out to its assessor and discussed the assessment. And what did the assessor determine? After looking at the numbers, the assessor admitted that the assessment was overstated. The assessor performed an income approach and cost approach of the property and concluded that the income approach was most relevant because he had 5 years of income information from Northgate. After performing this approach, he determined that the fair market value was $437,000. This is not an offer of settlement, it's a reassessment of the property. Shockingly, it's $475,000 less than what the assessor came up with the first time. This admission is on page 43 of Northgate's evidence. And again, in the other email, the assessor admits that on page 41, that the 2024 assessment was overstated. The assessor even told Northgate that he had reached out to the staff here at the tax commission about his reassessment because he claimed he needed approval, and the staff was apparently in agreement on that reassessment. This was not an offer of settlement. This was a reassessment and part of his obligations under Louisiana law. Yet shockingly, even after performing that reassessment, he refused to implement it. So Northgate was given one of two choices: accept a $437,000 assessment, or we'll go with the higher one. There was no offer of settlement. There was no discussion. There was no compromising because the assessor was unwilling to do so. He came up with a new calculation and a new assessment. And so it was a hostage situation. It wasn't a settlement negotiation, but that brings me to today. The assessor is attempting to hide these documents from the commission using a rule of evidence that clearly does not apply here. First, the objection is waived. These are emails with the assessor that were presented to the Board of Review. There's no objection there, and I understand that y'all are looking at the correctness of the assessment, but the first step of that process in the appeal process is going to the Board of Review, and simply there's no discussion of any objection to that document being considered by the Bossier Parish Police Jury. But second, I must emphasize that this is relevant and admissible evidence because it will help the commission decide consider the issues just next month. The emails show that the assessor is aware of the extreme overstatement, his use of erroneous assumptions in his income approach, and his continued reliance on erroneous assumptions. It also shows that the assessor refused to consider information by the taxpayer, including the storage center's functional obsolescence. As we set forth in our brief to the commission, the statements and the emails are not hearsay, and even if they are, there's tons of exceptions, so we're not even in that world either. So, because the assessor has no real good reason to have these excluded, they call them settlement negotiations. But these emails don't offer to settle anything. The emails show that the assessor performed a reassessment, then refused to implement it. The assessor was performing his statutory functions, and through that performance, he realized that his assessment was wrong and identified a lower number. The assessor could have and should have lowered the number once he performed his reassessment, but he refused to do so. This is not a settlement communication. This is an obvious and clear deviation from what the assessor must do under law. But even if the commission believes that this is somehow a settlement communication, Rule 408 is very limited in its scope. It clearly says, the article 408 says, the article does not require the exclusion of any evidence otherwise admissible merely because it was presented in the course of compromise negotiations. There are only two limited reasons why this could be excluded. The first is to prove liability or the amount of a claim. So if there's any other reason to present these to the commission, they're allowed in. And so we identify several other purposes that these emails can be used for. For example, the emails can be used to show that the assessor had access to 5 years of income information and did not do an income approach at first. And I need to point out something else that's important about the rule. The rule is aimed at protecting unsuspecting juries from being confused or receiving prejudicial information. If we were in a court today and a judge was presiding over the fact-finding mission, the rule would not be applied so stringently because judges are capable of discerning what is admissible and what is not. This commission is not a collection of jurors either, and much like a bench trial, you can determine what is admissible and what is relevant in those emails. So the rule can be applied with flexibility here, and the commission can give the evidence the weight it deserves. Exclusion of these emails is not required by Rule 408, and it's certainly not the answer here today. Finally, we did propose redacting parts that maybe the assessor finds offensive from those emails, and we gave an example of how we could do that as well. But for the reasons I've already stated and in our briefing, we do pray that the commission overrules this objection and allows the evidence in next month's hearing. Thank you for your time.
Mr. Eddington, comment?
Yeah, normally I don't, but I have to on this one. I mean, the suggestion that Assessor Edmiston undertook a reassessment, that he was not attempting to compromise a value for a prior year, is contradicted on the face of the records. I mean, the word reassessment never appears, and if there was a reassessment, obviously, Assessor Edmiston would have followed. What he proposed was a reduction in value and gave them a deadline to accept or reject it. That is a settlement offer. I want to be clear. We're not saying that this document is inadmissible because it was attached to a settlement offer. It, in fact, is a settlement offer. And also, I know we're not here on the merits, but he made a big point of that. I want to be clear that the settlement discussions were regarding the 2024 assessment. The case before the tax commission is 2025. There's been a staff appraisal that's actually higher than the assessor's valuation. They're attempting to use, they keep saying the assessor's trying to hide from these. They're settlement discussions. They're inadmissible. They're not inadmissible because of confusing a jury. I mean, that's nowhere in the law. The reason you had this exception is simply to further, in the matter of the public interest, the policy of encouraging settlement discussions. The reason they do that's very simple. That's so if people don't settle cases, the courts get clogged up. This is real simple. 408 specifically states, and I quote, evidence of conduct or statements made in compromised negotiations is likewise not admissible. If you review the emails, they are clearly statements made in compromised negotiations, and they are inadmissible. Thank you, Commissioners.
He gets the last word, but I will just say that while he might be correct that the word reassessment never appears in that email, neither does settlement or offer of compromise or anything like that. And again, the article does not require exclusion of any evidence otherwise admissible merely because it was exchanged in settlement communications.
Okay, thank you both. Questions from the commission? Hearing none, do I hear a motion?
Mr. Chairman, I move that we deny or overrule the assessor's written objection on the basis that the emails at issue do not reflect settlement discussions or negotiations. And to the extent they do, the commission can discern what is admissible and what is not admissible in the email communications.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Thank you, Commissioners.
Thank you, Commissioners. Have a great day. You want this side or that? This side. We got two of them.
Okay. I gotta swear everybody in here. All right, good morning. For those of you who have not gone through this exercise before, I'm an attorney for the Tax Commission. I will administer an oath to you globally. I will indicate to you individually to affirm the oath and to state your names. Please raise your right hands. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Gregory Miller, I do.
Thank you.
Russell Almaraz, I do.
Thank you.
Robert Yelverton, I do.
Thank you. Thank you. Y'all may have a seat. Appraisers, same exercise. Please raise your right hands. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Paul?
Paul Bennett, I do.
And George?
George Wallace, I do.
Very good, Chairman.
Thank you, Mr. Haltman. We'll hear from the taxpayer.
Okay, it's okay. The first appeal we'll take up this morning is the appeal of Yelverton Real Estate Holding Company LLC versus Assessor LG Williams in the Orleans Parish Board of Review, docket number 25221-73010.
Ready for me?
Yep.
Good morning, Mr. Chairman, Commissioners. I appreciate the opportunity for you to hear my appeal today. My name is Robert Yelverton. I'm the taxpayer. This is so far off of my normal beat. I hope you'll bear with me as I muddle my way through this appeal. In the interest of staying on track, I've got a prepared statement that I'd like to read so that I don't stray or abuse your time. Please pardon the level of detail. I believe they're relevant to this appeal and important to this proceeding. First, I'd like to provide some background that's led to this. My property sits on St. Catherine Island in the eastern Lake Pontchartrain Basin. The island's approximately 8 miles long and less than a mile wide at its widest point, with US Highway 90 as its only thoroughfare. Access to the island is across the Wrigley's Bridge and the aging Chef Menteur Pass Bridge, which is now closed indefinitely due to decrepit disrepair. The island is surrounded by the wetlands of Lakes Pontchartrain, Catherine, and Bourne. Public services on the island are extremely limited. We have electricity and gas, but no public water, sewer, or communications utilities. There is no law enforcement presence. Fire protection comes only from our privately funded volunteer fire department. There are no stores, no fuel stations, no schools, and no school transportation. I willingly contribute to these benefits that I do not have access to through the property taxes I pay, which is why an accurate assessment of my property's true value is important to me. In late 2020, Gateway Group investors purchased an approximate 2,500 acre tract of land on the island and subdivided it into 42 individual lots in 2021. The initial assessed fair market value for my property, my lot, for the 2022 tax year was $47,500. Because the majority of the island was owned by the Shepmenteur Land Company since the 1940s, there were no comparable land sales from which to base fair market value, making this valuation seem initially arbitrary. That same year, Gateway successfully appealed the initial assessment, reducing the fair market value to $18,000 on the basis of limited highest and best usable square footage. I purchased the subject property in March of 2022 for $15,000. For the 2026 tax year, the city of New Orleans raised their assessed market value of my property from $18,000 to $47,200, a 262% jump. I appealed this increase to the Orleans Parish Board of Review. My review was heard by Mr. Scott Spivey via video teleconference on September 25th, 2025. Shortly into my hearing my appeal, Mr. Spivey stopped me and told me the board was already familiar with my appeal. He said a clerical error had been made and that my appeal would be upheld. I asked him if anything written would be provided documenting the conversation we just had. He told me it would not be necessary and assured me that the error would be rectified. I documented the conversation myself. When I received my official decision notice on October 13th, I learned that it had not been upheld as I was told it would be. I called Mr. Spivey to discuss why. He said that my successful Board of Review appeal was overturned by Mr. Brent Ardino of the Orleans Parish Assessor's Office, and that my only recourse was to appeal to the Louisiana Tax Commission, which is why I'm before you this morning. I'd like to draw your attention to the projected slide as I discuss the property itself. My property is surveyed at 95 feet wide by 622 feet deep, or 59,046 square feet. The portion of the property that is buildable upland is surveyed at 95 by 142 feet, or 13,490 square feet. The first 55 feet of this parcel adjacent to Highway 90 at the very front of the property, indicated in yellow on the graphic, is a utility servitude leaving 8,265 square feet of deeded buildable upland. The remaining 45,556 square feet is entirely encumbered by jurisdictional wetlands regulated under Section 404 of the Clean Water Act. Further, this property has been subjected to intense coastal land loss from erosion, subsidence, and hydrological changes, resulting in the property's surveyed boundaries extending into adjacent water bodies, reducing the usable square footage even more so. Under Louisiana civil law, coastal erosion causing submergence of land abutting navigable waters typically results in those submerged bottoms becoming publicly owned and controlled by the state, with no deference to tax-assessed square footage, nor vice versa. This dynamic shoreline reality means an informed, willing buyer typically pays only for what remains practically and legally controllable and buildable upland. The wetlands and submerged portions should not contribute to the tax-assessed valuation calculus. Both the Parish Assessor's Office and the Louisiana Tax Commission appraisers utilized an appraisal method that applied a uniform per square foot valuation rate derived from local sales comparables to the entire 59,046 square feet, treating jurisdictional wetlands and submerged bottoms as equivalent to dry buildable upland. This approach doesn't seem fundamentally accurate. In the Louisiana coastal land market, informed sellers and buyers negotiate the price of wetland, constrained, and erosion-affected parcels based overwhelmingly on buildable square footage, not total gross area. Professional appraisal standards should mandate adjustments to comparables for differences in usable area, legal restrictions, environmental regulations, and high-end best use unique to the property being assessed. Ignoring these produces inflated valuations. The Louisiana revised statute defines fair market value as the price between willing, informed buyer and seller under ordinary circumstances, with the buyer aware of all the uses and purposes to which the property is best adapted and for which it can be legally used. Related statutory criteria also requires consideration of the property's individual characteristics, including physical and legal limitations. The assessment and foundational appraisals entered as exhibits to this hearing do not appear to meet this statutory standard by not distinguishing buildable upland from regulated wetlands and eroded submerged bottomlands. Additionally, the wetlands portion of my property may independently qualify as bona fide marshland eligible for statutory use value assessment. The use value tables prepared by this commission typically assigns very low per acre values to marshland based on limited traditional uses such as hunting, fishing, and trapping, reflecting its minimal income producing capacity. Even without pursuing separate classification here, this underpinning argument reinforces that fair market value must account for these severe market value limiting factors. In summary, the wetlands and submerged portion of my property, which makes up 86% of the total deeded square footage, should have negligible or even negative contributory value compared to the 14% dry usable upland portion for the following reasons. Absolute or near absolute prohibitions on wetland reclamation and development, high mitigation costs and marginal likelihood of obtaining favorable wetlands determination that would lead to the successful issue of a coastal use permit, severely restricted development potential caused by incomplete essential utilities and public services, limited alternative uses such as passive conservation or low-intensity recreational activities compounded by the historical and environmental context of the island, which prioritizes coastal protection and restoration over intensive private development. As such, I respectfully request this commission reject the City of New Orleans inflated $47,200 assessment for 2026 and restore the fair market value to the more realistic $18,000 valuation already determined by them under appeal in 2022. I know that's a lot, but thank you for your time as you ensure this assessment complies with Louisiana law, fair appraisal standards, and reflects the property's true economic reality within a dynamic coastal environment. Thank you.
Thank you. We'll hear from the New Orleans Assessor's Office.
Good morning, Commissioners. Greg Miller, Orleans Parish Assessor's Office. The property we're talking about, with the information given, was correct. The original assessment value was $47,200. That was upheld by the Board of Review. Our individual appraisal had a value of $53,000. We're asking for the $47,200 to be upheld, and the information pertaining to the servitudes and wetlands is accurate. However, it does affect the adjoining properties the same. They have the same buildable area, and it is available to look at via public records on wetland designation maps. Based on that, the comparable sales that were used in our appraisal are also affected by the servitudes and wetlands. We do have an exhibit also in our appraisal that shows all the land sales in the area that aren't specific to the appraisal, but are additional land sales to show the values that properties have sold for in the area. Based on the comparable sales in all of the properties being affected by similar wetlands and servitudes, we are relying on our appraisal and asking that the board, the commission hold the value of $47,200.
Okay, thank you. We'll hear from the LTC appraiser, Paul.
Paul Bennett with the Louisiana Tax Commission. I personally appraised the property at 22090 Chef Montour Highway with a land value of $32,500.
Questions from the commission?
Mr. Chair, I have questions relative to the, I guess, the consideration of first the assessor's office and I guess just the commentary on comparable sales and understanding a uniformity in rate per square. But the comment on the usable space in comparison to the total land deed, if there has been erosion, then that deed or that property does secede to no longer to the owner. So is there any consideration of the usable space in your assessment?
As exhibited by the map that was shown, the erosion is in the area that is not in the buildable area. It would be in the area that is considered wetlands. The part
Correct,
of
but the
area
original
that is
deed of the
buildable
I'm
has
sorry.
no water contact.
The total land quantity of 59,000 includes that portion that is no longer usable?
The portion that is shown here in pink is not usable or buildable. That is the designated wetland area. The portion in the green is what is buildable, and basically the dotted line that goes across the top is what is predominantly buildable on each lot.
So the assessment of the 47,200 is on the usable portion.
It's on the total, however, the usable, as I stated on the comparable sales, is. Yes. Yes. Yes, the value is stated as a price per square foot, and it is included on the entire lot.
And Mr. Bennett, the same in your assessment.
Yes, that is correct.
And for the taxpayer, your position is that you should only be assessed on the usable component.
That's correct, sir. The original developer of the property took the original assessed value of 47,500 and appealed that assessment and had it lowered. And it was the judgment of the board and the Orleans Parish assessor at the time that it was overvalued, and they reduced it to 18,000, which is the assessment that I purchased the land under. That's also reflected in my purchase price. If you.
But you have nothing in writing from the Board of Review.
Sorry?
Nothing in writing from the Board of Review, just the oral discussion with the member of the Board of Review.
Nothing in writing. The only thing that I received in October was a notice that what I was told verbally in my appeal to the board was that it would be corrected. It was an error and it would be corrected. It was not, and that's the only communication. I attempted to call several times. Mr. Spivey was the only one after numerous phone calls that responded. But the Orleans Parish Assessor's Office, I tried to reach out to Mr. Ardeno. All of my messages, calls were left unanswered. So it left me with the only recourse was to engage with you guys.
Understood. Thank you.
I would like to point out, Ms. Banks, if you could bring that, the view of Mr. Bennett's, he put a parcel map in page 2 of his appraisal. I don't know if you have that ready or. Yes, can you zoom in on that? And just center my lot that's got the blue around it. So if you'll note, so the white up there is a prior impact home site that was very close to the road that goes back to the 40s. That's so the first 55 feet of that, which is where it's demarcated by that solid line, which is the forward property line. You can see what's usable. Everything else is native salt marsh wetlands. I've got a little bit of experience with coastal use permitting. They will not let me access or reclaim any of that, and I wouldn't want to. And you can see that the property line extends well out into the Marquez Canal. So significant storm erosion over since Katrina, as well as some edging over along the marsh that's encroached well into the lot. I just don't see how that can be included in the square footage calculus when the only thing that I have access to is the 8,000 square feet that's in the very front. The rest, it would I have to view it as a conservation of native wetlands. So if you take these appraisals and you take the square footage, the uniform square footage value that they've assigned to derive these very high numbers, if you doubled their highest value per square foot valuation and you multiplied that times the 8,000 square feet, approximately 8,000 square feet, let's say it's $2 a square foot, times 8,000, that's still only $16,000 of value. I'm asking for it to be restored to what they said it was back when the original developer had it, appealed it, and had it reduced from 47,500 down to 18,000. I paid that. They were content with me paying property tax on an $18,000 valuation for 3 years. Nothing's changed, but yet this year they raised it 262%. I don't think that's an accurate assessment of the value of that property at all. Mr. Bennett, in his appraisal, he cites that the wild variations between the sale price of these 42 lots that are unique to that end of the island was highly variable, and that was unexplainable. So he took an averaged approach. But the reason it's highly variable is that the developer takes into account the square footage of dry, buildable, usable upland for that specific lot. So there are some that have half of the square footage of that lot has been backfilled. Prior impacted real property there was significantly more. And so therefore it commanded a higher sales price. But then you take my lot where there's 8,000 feet compared to 50,000 square feet on some of these properties they cited, that has far more usable, buildable land. Mine has 8,000. And I think you can tell by this aerial view that truly 86% by square footage will never be usable to me. And I would be hard pressed if I were to sell this to make an argument to an informed potential buyer that they would be willing to pay a uniform per square foot value for the majority of that lot that he'll never be able to recover or do anything with. Just like I didn't. I paid $15,000 for it.
Mr. Chairman,
Thank you.
if you would, I have a question. Mr. Russell, can you help me understand, because it's a lot to take in,
Yes.
the reason for the increase? Because
So-
I'm hearing two different.
Sure. I'd like to clarify a couple of things. First of all, Brent Ardno is an appraiser for the Orleans Parish Assessor's Office. Brent Ardno did not overrule the Board of Review's determination. The Assessor's Office cannot overrule a Board of Review determination. By statute, a Board of Review is a review board for the Assessor's Office, is the first step of appeal. Then subsequently goes to the Louisiana Tax Commission as we're here today. So I just wanted to clear that for you. Mr. Ardno did not overrule Mr. Scott Spivey for his valuation.
Who did?
I don't know. You'd have to ask Mr. Spivey. Mr. Spivey made his own ruling, and it could have been the city council, who was actually the Board of Review. Mr. Spivey is just a subcontractor for the Board of Review and not the actual Board of Review itself. Now, the other thing I'd like to say is that in order for this property to be wetlands and have a use value, it needs meet certain criteria, which is be 3 square footage of 3 acres or more, and it has to be under the jurisdiction of the Army Corps of Engineers. He has to file an application with the Army Corps of Engineers and get it redone every 5 years to get use value. That has not happened, so we're not
No.
not
it has.
qualifying it as,
Oh, I'm sorry. I'm sorry.
so we're not qualifying it until we get a letter from the Army Corps of Engineers stating that it's use value, then we can apply the use value. The other thing I'd like to say is he may not be able to build. Can you pull up the parcel again, please? He may not be able to build on it. The buildable area may be, and if I may approach the screen. The buildable area may be this section right here, right? The water section is here. This entire property has a value. This value may not be the same as that, but the values of sales of dry land are $1.60 a square foot. Now, the $1.60 a square foot is reduced when you factor in a reduced rate for this value, which is where the $47,200 is coming in. We're not saying that the entire 50 cents a square foot is for this entire thing, and then there's no delineation between these two. We're saying that this is $1.60. This is a lot less than $1.60. Together, it comes out for a value of 50 cents a square foot, because we have to have one value for this entire property. It's one tax bill, it gets one value, right? There's delineation and demarcation between two different values. That combined reduces the large value for the buildable area. This guy right here has a little bit less of buildable area because he doesn't have the side that juts out. His price per square foot is the same as this price per square foot when they have roughly the same amount of buildable area. This is a uniform value based on lot sizes and this reduced rate based on buildable area. Now, the other thing I'd like to say is that most of our sales are $1.60 a square foot for median, average $1.83. He has access to this property. The value is a lot less than $1.83 a square foot because we're taking into consideration part of that land is not underwater, but marsh. And I'd furthermore like to say that if you have lake frontage, like all the lakes in the New Orleans East, they have lake frontage, they have water frontage. They have part of their property is underwater in that lake. There's inherent value to that property. Just because it's underwater does not mean that there's any value to that property. There is a premium for water frontage property. And so we cannot say that, or you cannot say that just because the property is in the water, it has no value. That is your property. You bought it. You knew the stuff going into it. It's not buildable. It's not unusable. You can use the property. You just can't build on the property. That's what we got to keep in consideration. And also, the $18,000 value is a pre-quadrennial valuation. 2022, 2023 is a previous quadrennial with a lien date of 1/1/2019. 2024 starts the first quadrennial with a lien date of 1/1/23. So we can't equate what happened in the past to apply forward. Market value changes between quadrennials.
Any other comment from the taxpayer?
So just the comment about Mr. Ardenault, I'm just repeating what Mr. Spivey reported to me. I tried to talk to him to.
And I'm going to stop you, and I'm not dismissing it. The assessor's office has no authority to overrule the Board of Review in any parish in the state. In most things, it's the government is the jurisdiction. So if the council overruled it, which may have happened, may not have happened, it wasn't the assessor's office because they do not have that authority to do that.
Right. Like I said, this is so far off of my beat, my normal beat, so this is the first time I heard this. I tried to engage to hear from them. It might have been a different perspective. My perspective would have been different if I were able to talk to Mr. Ardenault and he could tell me, he could have told me then that I didn't make that decision. This person did. The only correspondence that I got was just this decision notice. And the way it looks to me was it says the Orleans Parish Board of Review has considered the appeal. That's a very small print, but basically says no change. So on the surface, everything that I had in front of me was suggesting that the board said it was upheld, then said it wasn't. And so
You were told verbally, but once again, just to be clear, the New Orleans Assessor's Office does not control the Board of Review. It's not like that in any parish. It's specifically set up that way so that if you're not happy with the assessor, you go to the Board of Review. In most cases, it's the governing body is ultimately it. Parish, police jury, parish council, city government, city council, and then you come to the taxpayer. So I'm not disputing what Mr. Spivey may have not have said, but if you were told that the assessor's office overruled that, that's incorrect because they do not have the authority to do that.
I acknowledge that now. I know that now. I didn't know it leading up to today.
Okay. Any additional questions from the commission?
I do have one last parting comment. Nowhere in these appraisals, either one of them talks about a varied, that the buildable land has a per square footage value of $1.60, and then the rest is less, and then those two rates are averaged. That doesn't, I don't see that anywhere in any of these appraisals. It seems that would be an important thing to note, is that the buildable has a higher per square foot rate than the rest. What it projects is a uniform of however that square footage is derived. It seems to me the way it looks in the appraisal is total square footage divided by the sales price equals some per square foot value. And then it says in the appraisals that an averaging approach was taken. Doesn't discuss at all that there's two specific rates for wetlands, one rate, buildable upland, another rate, and those two are averaged. So thank you. Ken.
Any additional questions from the commission? Hear none, do I hear a motion?
Mr. Chair, I call for a motion from what the assessor says to the LTC appraisal, I'll cut it right in half at $39,850 for land value.
Do I have a motion? Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted. $39,800.
Thank you. Yes. Okay. Okay, thank you.
We can call the next appeal, please.
Next, we have the dual appeal of Assessor LG Williams versus 930 Porges LLC in the Orleans Parish Board of Review, docket number 25221-71027, and the appeal of 930 Porges LLC versus Assessor LG Williams in the Orleans Parish Board of Review, docket number 25221-71041.
Okay, since it's a dual appeal, you want to flip who goes first?
Rock, paper, scissors? You go first, Carl.
Okay, appreciate it. Take a second to get myself set up here. Good morning, Commissioners. I appreciate your time today. The appeal before you today is well, I guess I first ought to comment, make the comment that we haven't received the assessor's data until 12 days before the original. This is a rescheduled hearing. It was originally scheduled for March 25th, and it's a dual appeal. Both parties have that 45-day window to submit their data. We did so 46 days before. We received the assessor's data only, 12 days before that original hearing date. So I just want to note that for the record, ask the commission to not give it any weight. I don't want this hearing to be about hearing about objections, but I just wanted to note that for the record, and just have
Duly
that in
noted.
there. Thank you. This is a 502 space self-park garage located at 930 Porges. It has about 8,200 square feet of commercial retail space in the ground floor that is now going to be about 2/3 vacant in a couple of weeks. And this was well known for a long extended period of time, the troubles that this retail tenant has had. It's true that the LTC has heard this matter last year as well. I'm sure in the assessor's oral testimony, it's going to come out that there's a settlement hearing, or a settlement rather, a consent settlement that was entered into for 2024. That is true as well. That was March 24, and if you recall, and I think it was in last year's decision, that settlement was entered into as a means to facilitate the transfer of the property from the Industrial Development Board. It was formerly under a pilot agreement to the private ownership. And rather than be confronted with a exorbitant and almost insurmountable protest payment that they would have to make, they entered into the settlement agreement of roughly $10 million, a little over $10 million for that value for that year, with the understanding that they could then present their case in subsequent years, talking about the property's plight, its financial deterioration over the years. So that is why we're here before you today. The property, if I can then, I mentioned its financial condition continues to deteriorate. The largest tenant, Johnny Sanchez, exercised an option to terminate their lease, and that commercial space is now going to be about 2/3 vacant. That letter from Johnny Sanchez is contained in Taxpayer Exhibit 1, Item 3.
This was well known, as I had mentioned. Johnny Sanchez has been in arrears from 2022 to the current date in various amounts and various levels in arrears over that period of time for rent charges, CAM charges. Just last Friday, it was NOLA.com came out with an article about how Johnny Sanchez is closing their restaurants in New Orleans, and they specifically mention the location at the subject property. And he's quoted as saying, "We're very hopeful it would turn around, but it hasn't since COVID. We're just not able to ride it out. It was a tough decision." His letter in the appeal evidence, as I mentioned, that is item number 3. He talks about, and specifically it's outlined in there, that he will make good faith efforts to remain open through the end of the lease term, but they recognize day-to-day operations must ultimately be guided by business realities. So this is something that was on the horizon and that they were very well aware of. The operational income history for the past 10 years, from 2014 to 2024, is depicted as well in our exhibits, item number 4, and it shows this kind of steady decline on a net operating income per space. I mean, it gives a total as well, but then looking at it on a per parking space amount, that amount it's 50% of what it was from 2020 to 2024. 38% decline just in the past 2 years from 2022 to the end of 2024. Part of that is Shell Oil canceled their lease at December 31, 2023. Shell, I think it's no secret, they've made this announcement. They're actually moving out of downtown, moving out of the DDD, building their own facility on the other side of the Pontchartrain Expressway, in what is now I think it's called the River District Development. It coincides with that, as well as Shell's contraction over the years, where their presence in New Orleans has steadily declined. But the downward trend is indicative that the subject property suffers from poor location, low demand for parking. The demand for parking in this immediate area is really confined to the limited special events that happen at either the Smoothie King Center, the Superdome. All the office buildings and residential complexes in the immediate vicinity have their own dedicated parking spaces. The demand for parking remains near the French Quarter, Canal Street, Poydras Street, and near the new Caesars Casino. So it's difficult for this property to generate the level of income that it needs. Our request of value is $7,537,000. The tax commission's appraisal is just a little over $8 million. Last year, if I can summarize, it was in the decision or some of the minutes in my own recollection of it, the tax commission just kind of merely averaged the assessor's income value and the taxpayer's income value. So it was kind of a split between the difference, and we don't think that it gave enough weighting to the subject's plight, with the realities that this subject property knew were happening, 3 years ago. So that is my presentation. As I mentioned, I do have some commentary on the assessor's evidence that they've submitted, to the extent that it becomes part of this discussion. I have some commentary.
Before we move in before Russell, so Carl, are you formally objecting to the assessor's exhibits?
Yes.
Okay, so now we're gonna have to rule on that, unless
Okay.
Russell, you're gonna discuss something that does not pertain to your exhibits.
Okay.
Be the option to.
Okay, yeah.
Yeah, I got you.
Appreciate it.
So it was, yeah, I got you. So, that was continued. It wasn't continued by our request. So it was continued prior to us submitting the exhibit. So I was on assumption that the exhibit deadline would be the date that it was moved to. I'm not sure who requested the continuance, but it wasn't ours. So yeah, it wasn't done 45 days before the original hearing. It was done 45 days prior to the actual date of today. So I'm not sure where that was. Also, it's a dual appeal, so it would only need to be 30 days. There's the same exhibits, whether it's my exhibits for my appeal or my exhibits for his appeal. So even if it wasn't 45 days, it was at least 30 days prior to the new date. So I'm not sure exactly what was going on, because I was on the assumption that we had because it was not our continuation, that we had the ability to submit our exhibits.
Mr. Hoffman, want to comment? Typically, when we agree to a continuance, we do not extend the date for exhibits.
Sure,
We,
because the party that is actually doing the continuance is the one that's actually going to get the
we
discussion.
typically do not extend the date for the continuance, whatever was the date. If you called and got stuck in traffic, or you got caught at a flat tire and said, can we push the meeting? We would push the meeting. We don't extend the dates, but I will let Mr. Hoffman
If I
comment.
may clarify, then I did not request that extension.
Ms. Malvo is investigating. She believes it may have been the meeting we decided to cancel. But she's investigating when the parties were notified that the hearing would be continued. Because if they weren't notified until more than 45 days prior to the meeting, the exhibit should have been submitted, because the assessor didn't have a crystal ball and didn't know that we were going to continue the meeting.
If I can add, I mean, I just have some notes, and I think I got an email on Wednesday, March 11th, that it was going to be rescheduled.
So if the original hearing date was March 22nd, 25th, and the parties weren't notified till March 7th, then the assessor's exhibit should have already been submitted before they found out about the continuance, and they weren't. And Ms. Malvo has confirmed the commission continued the hearing because I believe it was the only appeal on the docket, and so we moved it.
But that would not have changed the dates to submit.
But the assessor's exhibit should have already been submitted by the time they learned that the hearing was being continued.
So, want to comment on your exhibits, or you don't, or you want to have a discussion without them? Mr. Rule on an objection to the exhibits.
I mean, I could do oral testimony. It doesn't, it's not going to change.
All good. What I don't want is every sentence you say, Carl's going to object it. That's part of your exhibits, part of your exhibits. Either we'll have an agreement that we're going to try to do it without it, or we will rule on the admissibility of the exhibits.
Mm-hmm. And I'm happy with just talking about this, because I think our case stands on its merits, and we're happy just to have the conversation with whatever the assessor wants to talk about and their data, and so.
So the issue, Carl, is you've objected to the exhibit. So the commission needs
Okay.
to make a ruling on whether or not we're going to consider those exhibits and accept them into the record, unless you're withdrawing the objection. If you're standing on the objection, the commission has to rule on the objection, whether they're going to consider the exhibits or not. What I heard you say before is you were objecting to the exhibits.
Yes, okay.
Okay.
Thank you. Yes.
So before the commission is an objection to all of the assessor's exhibits, the written exhibits. I think, yeah, you haven't asked me for a recommendation. I don't have to give you one, but based on what we've heard, the original hearing date on March 25th, the assessor exhibit should have already been submitted, and they weren't before they learned about the continuance. And I don't believe the rescheduling notice extended the deadlines. We don't typically issue a new case management order extending the deadlines. So the original deadline should control.
So the question, as Mr. Hoffman explained it, is we did continue the meeting at our accord, asked the request, but that was after the deadline to submit the records and all exhibits in by that time. I'm assuming in other cases, those exhibits were turned in after that date. So we need to decide, are we going to allow them or we're not going to allow them?
Correct, Chairman.
So I'd open it up for questions or comments from the commission.
I'm going to go and make a motion that we keep them out if they didn't make it by the original deadline. So I'm going to make a motion to uphold the objection.
Yeah,
of
so
the
Commissioner
exhibits.
Frazier's motion would be to sustain the objection to exclude the exhibits from consideration.
Okay, we have a motion. Any discussion from the commission? Any objection? Hearing none, motion is adopted. The
Okay.
exhibits are not going to be admissible.
So the exhibits will be stricken. They will not be contained in the administrative record for this appeal hearing. But certainly, Mr. Alvarez can testify as to what the.
Any
effect
oral testimony is allowed.
As long as you don't refer to the exhibits.
Sure. Okay, so the assessor's position is that this property is a commercial business on Poydras Street. We had a settlement with the taxpayer in 2024 for $10,040,000. That was not palatable for the taxpayer. He appealed to the commission. The commission originally ruled at $950,000. I think it was $9,950,000. It was a incorrect ruling. Some of the numbers got transposed, so they did a correction for $9,095,000 total value. The assessor went ahead and made change orders for the following years for that value. The taxpayer decided to appeal because the taxpayer appeals every year on this property. I'm assuming if the commission upholds their ruling that they made last year for $9,095,000, the taxpayer will appeal again next year. The taxpayer is stating in his own words that Johnny Sanchez has filed a letter to terminate their lease, but the lease is currently active as of today. Johnny Sanchez is operating business as of today, so that revenue is not gone as of today, which is well after the deadline of 1/1/2025. So the also for the commission's knowledge, not included in our exhibits, is that there is another business that has recently opened. I want to say it was about 7 months ago. It was another Mexican restaurant that opened up where the defunct Reginelli's was. So that is additional revenue that the property is receiving. So the question is, the taxpayer comes every single year and says that we need to revalue this property every single year based on the status of the property every single year when there's a deficit, and tries to get a reduction in value. However, the taxpayer is the same taxpayer that says that we can only value once every 4 years when we try to raise a value based on changes of character or new tenants coming in. So I'm just trying to find out, what is our objective? Do we value property every quadrennial? Do we value property every single year? And if that's the case, then can we raise the value now that there's going to be another tenant in, that the property was the $9,095,000 decision did not include the new tenant that's currently in there. So does that mean we get to raise the value now that there's a new tenant that wasn't included in the original decision? We're just asking the commission to uphold the decision they made last year. We're not asking for an increase. We're just trying to get a little clarification.
Okay, so and I just want to be sure before we hear from the LTC appraiser, the assessor's office is asking for $9,095,000. The taxpayer, Carl, is asking for $7,500,000, or is that right? Just make sure we have the right numbers.
$7,537,000.
We'll hear from the LTC appraiser, Mr. Wallace.
Yes, sir. Good morning, George Wallace with the Louisiana Tax Commission. I did complete an appraisal at 930 Poydras Avenue. The land value was uncontested at $1,588,400. I completed a cost approach at $9,354,000. I did an income approach with the actual rents for 2022 and 23, and came up at a value of $8,050,000. And the final estimate of value, I relied on the income approach at $8,050,000. That's $1,588,400 for the land, $6,461,600 for the improvements.
Thank you, Mr. Wallace. Questions from the commission? Hearing none, do I hear a motion?
Mr. Chair, I'd like to make a motion to stay at our decision last year. That'll be $9,095,000 total value. That's $1,588,400 on the land and $7,506,600 on the improvement.
Here we have a motion. Any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Thank you. Appreciate it.
Our final appeal of the morning is the appeal of King Cake Real Estate LLC versus Assessor L.G. Williams in the Orleans Parish Board of Review, docket number 25221-71012. No taxpayer present.
Taxpayer rep, we'll hear from the New Orleans Assessor's Office.
Yes. Good morning, Commissioners. Russell Amraz for the Assessor's Office. So this property was valued at $375,000. It was affirmed by the Board of Review. I believe the $375,000 was a decision from '24 that we've carried forward. We did a fee simple appraisal that came out at $447. We're just asking the commission to affirm the Board of Review's value at $375.
Thank you, Russell. We'll hear from George, LTC appraiser.
Yes, sir. George Wallace again, Louisiana Tax Commission. I did the sales comparison approach and had a value of $375,000, an income approach at $337,000, and I correlated the final number at $360,000. That would be $88,900 for the land and $271,100 for the improvements.
Thank you, George. Questions from the commission? Hear none, do I hear a motion?
Mr. Chairman, I move that we accept the Orleans Parish Assessor's offer at $375,000 total, with land being at $88,900, with the improvements at $286,100, for a grand total of $375,000, Mr. Chairman.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. Any other business to come before the commission? Hearing none, do I hear a motion to adjourn?
Mr. Chair, I call for a motion to adjourn.
Any discussion on the motion? Any objection? Hearing none, we are adjourned. 10:16 a.m. Thank you all.